Title IX, a great landmark law that creates equality for all. Landmark law created in June of 1972. This law has taken over 40 years to work towards bringing gender equality. The law was created to bring schools into compliance. Title IX, a law that became law to end all laws, a statute that was created to create equality for all sexes. Title IX was placed by Congress and became law in 1972. 9 hardworking people created and put this law in place. These people were Patsy Mink, Elizabeth, Starlett, Green, Birch, Bay, Bedrees, Sandler, Danya, Lapino, Betty Jean King, and the plaintiffs of Alexander versus Yale, David and Mara Sacker, and Benita Miller. All 9 people had a similar passion and drive, which was they wanted to put together a law that would protect women and minorities from sexual harassment and discrimination. They and others helped create and build an environment in our schools that would promote equality for all. The law helped create a law called Title IX, which is a very broad law that covers sexual discrimination, harassment, and the law also oversees financial aid and how it's used and how it's distributed and who receives it. The area that I've decided to focus on is harassment and discrimination for women and minority students and staff, and how schools have used this law to protect and create equality in all of our schools. Now let's review some information about the case. The case again became law in 1972 and had many changes over the years. Essentially, Title IX prohibits sexual discrimination in educational institutions which receive funding in most schools. While Title IX is a very short statute, Supreme Court decisions and guidance from the U.S. Department of Education have given it a broad scope covering sexual harassment and school violence. Under Title IX, schools are legally required to respond and remedy hostile educational environments, and failure to do so is a violation that means a school could risk losing financial funding. To understand the specifics requirements of Title IX, schools receiving financial aid, including private K-1 schools and most universities, must look at guidance materials from U.S. Department of Education. Recently released 2017 interim guidance discusses the obligations schools must address campus sexual violence. While guidance documents are not law, they describe to schools how the department will review and enforce Title IX complaints. Under Title IX, schools must disseminate a notice of non-discrimination. This notice does not have to specify that sexual harassment and violence are likely prohibited, but the U.S. Department of Education recommends the schools do. Since a notice that makes it unclear may qualify as a violence of Title IX, this notice is likely available in a student handbook or code of conduct in elementary and secondary schools, in an annual security report, ASR, in high education institutions. This notice prohibits sexual discrimination, must be widely distributed, available and easy accessible to the school community each year. ED recommends schools publish this policy online and have it available in print across campus so that school members may understand its purpose and utility. Include enough detail in the policy that members of the community can realize sexual harassment and sexual violence are prohibited forms of sexual discrimination. Progress of the U.S. Supreme Court. Discrimination of women in sports dates all the way back to the 1800s. They wanted to be more involved in sports and wanted to receive equal treatment. So for years they struggled to gain respect they deserved. A new wave of feminine within large social reforms south by civil rights movements, women moved closer to legislation action for greater equal treatment in athletics. The concept that federal legislation was to eliminate sexual discrimination was the focus for women's groups in the late 1960s and early 1970s. At their first national conference in 1967, the National Organization for Women, NOW, adopted a platform that would read in part, "The rights of women to be educated to their fullest potential equality by men be scored by federal and state legislative Bose 1889, page 643. Title IX of Education Amendments of 1972 was paid little attention in early legislation efforts to codify these rights. Court ordered busying in other titles of Obama's education amendments took spotlight. Pauley versus Preston, 1978. It was only after Title IX was passed that questions surrounding implement arose, that opposition to Title IX took place. Gabley and Perley, 1978. After the passage of Title IX, Congress built in a 6-year period for secondary and post-secondary schools to achieve compliance. The dates for compliance by colleges and universities was 1978. Implementing and enforcing them were vested in the Department of Health, Education, and Welfare, Carpenter, 1993. Summary and opinion and dissent. On June 23rd of 1972, the President signed Title IX of the Educational Amendment of 1972, 20 U.S.C. Supplement into law. Title IX is a comprehensive federal law that prohibits discrimination on the basis of sex, any federal funding, education programs, or activities. The principal objective of Title IX is to avoid the use of federal funds to support sexual discrimination in educational programs and to provide individual citizens effective protection against those practices. Title IX applies with a few specific exceptions to all aspects of federal funding, educational programs, or activities. In addition to traditional education institutions such as colleges, universities, and elementary schools and secondary schools, Title IX also applies to any educational or training program operated by a recipient of federal funding assistance. The Department of Education has issued regulations on requirements of Title IX. The Title IX Common Rule, published August 30th of 2000, covers educational program providers, recipients that are funded or by other federal agencies. The main changes that have been made over the last 25 years since the law was put in place date back to 1972. Most have been in the area of compliance and getting tougher on schools and how they handle the individual cases and how they document their procedures and how they make sure that they move towards a zero tolerance for any type of discrimination. Impact of the case. Since 1972, women have made great strides in their educational attainment, benefiting from protections enacted through Title IX. In 2009, approximately 87% of women had at least a high school education, and approximately 28% of these women had at least a college education, up from 59% with a high school education and 8% with college degrees in 1970. Additionally, enrollment in higher education has increased at a greater rate for females than for males. Since 1968, the percentage of women between ages 25 and 34 with at least a college degree has more than tripled. Office for Civil Rights, U.S. Department of Education, available to women have had higher graduation rates and lower high school dropout rates. Take more advanced placements exams and earn more advanced degrees than their male counterparts. They also tend to score higher in reading assessment tests than male students. A graph attached page 6 shows that since the law has changed the graduation rates for women and created more equality for them and others. The graph listed on page 7 also shows the impact of the law, that more women are involved in sports and how it's directly linked the changes in the educational system and has benefited others overall. Because of these changes, there is now more participation in the labor force. Women have also increased earnings, had better health, and better access to health care. The benefits of Title IX have extended far beyond the experience in school. Additionally, the benefits of Title IX have reached beyond the realization by most women. By providing schools and making them treat students differently, this has stopped bias related to sexual discrimination. Title IX allows both men and women to be treated equally and take advantage of courses of study regardless of gender stereotypes that had been traditionally for male and female course work or professors. Title IX protection against harassment applies to both sexes, and schools must act to prevent sexual harassment and that interfaces with educational requirements for both male and female. My personal opinion that this case has helped bring about more equality for not only females but also for minorities and all humans. This law levels the equality field and forces schools and government agencies to be more accountable for their actions, whether it's our elementary schools all the way up to colleges. They all have to follow the same rules, and they are all held accountable for their actions, and this has created equality for all, and it continues to get better.